Good morning or afternoon. Welcome to today's webinar. I hope everyone can hear me okay. I am Alicia Fuller. I am a member of the State Bar of South Dakota and specifically the CLE committee. Not that it matters, but I work at the Federal Defenders out in Rapid City. Before we get started, I have to cover a few things so that you know how to participate in today's event. The first thing we'd like to cover is just a reminder that Lawyers Concerned for Lawyers is out there with the State Bar. And if you or a lawyer, law student, have a drug or alcohol problem or are struggling with depression or anxiety, Lawyers Concerned for Lawyers is a confidential and independent resource for South Dakota lawyers, law students, and their families. Your referral or visit with L4L is strictly confidential and privileged. If you would like to reach out, call Becky Porter for more information. She's at 605-394-5191. She's a LCL member, and your communications with hers are likewise confidential and privileged. Today's presentation will last approximately 1 hour. The materials, you'll be seeing a series of slides by Professor Rose, but the materials are in PDF form under handouts. You will have the opportunity to submit questions today, but I'd ask you do so by typing the questions into the questions panes of the control panel. You can send them in at any time. We'll collect them and address them during the question and answer session at the end of today's presentations. We'd like to thank the State Bar of South Dakota and CLE Inc. for their support of today's program. Now the reason everybody's here to listen to Professor Laura Rose. She continues to teach her beloved courses of evidence and trial techniques at the USD Knudsen School of Law. She was elected to a 3-year term on the board of directors of the National Association of Legal Advocacy Educators as the Region 12 representative. In this role, she represents the interests and concerns of advocacy professors in North Dakota, South Dakota, Minnesota, Iowa, Nebraska, and Wisconsin. Professor Rose is involved with the trial advocacy consulting and training as an instructor and presenter, and also National Institute for Trial Advocacy. Her article, Advocacy in Action, Teaching Evidence to Interleave the Doctrinal and Practical, was selected as the inaugural winner of Stetson University College of Law's Advocacy Writing Competition. At USD Knudsen School of Law, Professor Rose continues to grow the trial team. The trial team looks forward to its new competitive tryout process in the spring of 2021 and always welcomes South Dakota lawyers who would like to get more involved. And with that, I will turn it over to Professor Rose for her presentation.
I promise I'm not going to keep the webcam up the whole time. I just feel weird if I don't say hi to everybody. So hello, everyone, and welcome to our presentation where we're going to demystify the objections process, give you a roadmap that will allow your brain to go there when it's in a panic situation, and then walk through some of the common objections and how we're going to deal with them. A quick note before we begin, when we get into the rules section, this is going to be grounded in the federal rules of evidence, not the South Dakota rules of evidence. But fortunately for us, we're basically a copy paste except for a few things. So make sure that you're paying attention as we go through today. So we all know that when it comes to objections, the ultimate temptation is to get into a contest with opposing counsel about who is right and who is wrong. And at some point, you have to realize that that's not what this process is about. Instead, we need to create for ourselves a format when we're dealing with objections that allows us to have just that little bit extra of brain space. When we're in trial and things are flying at us a mile a minute and everything's on fire and we're not quite sure if that's the alternate or the head jury person, but they really don't like our case, anything that can save us time is going to be worth its weight in gold. And so I give to you this format. First thing that we're going to do, we're going to stand and we're going to object with the grounds that we are objecting under. We'll ask to approach the judge, then we're going to make the argument, and then we're going to ask the judge for what we want. Now, this may sound familiar to some of you out there. Some of you out there may be thinking, hey, wait a minute, at some point I took a legal research and writing class, and this sounds a lot like issue, rule, analysis, conclusion. If you had that thought, good, because that's exactly what it is. We are building on our psychological scaffolding. When we object with grounds, I understand that in South Dakota, there are judges who prefer that we don't object, but there is a power in getting out of your chair when we're making an objection, particularly if it's something that we need the judge to pay attention to. When it comes to how we object, timing is everything. If you're objecting to the question, you should be objecting as soon as the question is finished. If the objection is to the answer, your objection needs to come before the next question begins. That can be a difficult thing to do, particularly if you have somebody who is a fast-paced talker such as myself, but you have to train your ear to listen and to be up. Your tone of voice is going to convey your intent. Are you objecting something because of a formality, or are you objecting to something because it is a true infringement on your client's rights? Let's talk about interrupting opposing counsel and the witness. Certain rules, certain objections, certain situations are going to call for you to have to do the ultimate thing that we don't want to do here in the Midwest. You're going to have to interrupt. You're going to have to stop the proceedings as they are happening and make sure that your voice is heard. Why? Because the entire purpose of objections is to protect the rights guaranteed to each of us under the 6th and 7th Amendment to the U.S. Constitution. If we don't properly preserve those rights under the rules of evidence, then we are not doing our job as attorneys. When we ask to approach, make sure you ask and make sure you listen to the judge, because occasionally, as we all are very familiar with, judges are going to make up their minds on their own. They're going to have already decided what their ruling to your objection is before you've even made the objection in a lot of cases, but stop and wait and see what they want to do. Situational awareness is absolutely everything in a court of law. Paying attention not just to what is going on with opposing counsel and the witness and the jury, but also the judge. Recognize when you don't need to make the argument. Recognize when that judge has done the legal calculus in their head and is already agreeing with you. You can cause yourself more problems if you start to argue when you don't actually need to. Finally, let's talk about recognizing when to make an offer of proof. An offer of proof is essentially a great big red flag that you are waving in front of the judge that says, hey, judge, you gave this ruling. I now have to go a totally different direction in my case, and I'm going to end up appealing you, which is the ultimate threat / promise that we as trial attorneys can make. Judges don't want to be appealed. Judges don't want to be overturned. It is a way for you to get the judge to pause and reflect on their ruling before they decide where they're ultimately going to go. The argument itself is, again, this is that IRAC format that we were talking about earlier. You're going to state what rule of evidence you're arguing under. You're going to then analyze what's just happened in the courtroom under those rules of evidence. And it doesn't always have to be a super long argument. And sometimes shorter is in fact better, despite what we all want to believe as presenters and as people who like to talk, right? Keeping it concise, keeping it simple, going straight to the heart of the argument and straight to the point. Judge, I'm objecting on relevance under 401 and 403. Any slight relevance that this piece of evidence may have is the prejudicial value of it substantially outweighs any probative effect that it may have, and therefore it must be excluded here today. We'd ask the testimony to be stricken. What is that? Issue, rule, analysis, conclusion, as quickly and efficiently as possible. When you ask the judge for what you want, if you get something excluded, you heard me say I'd move to strike the testimony. I need to make sure that I do that anytime that I get what I want out of an objection. Why? Because it's about preserving the record. The thing that I always think about when I am conducting trial work, and the thing I encourage my students to think about, is someday some appellate attorney is going to have to look at the transcript of your work. You want that to be as clean as it possibly can be. You want to create the best record possible so that when your case gets attacked on appeal, your appellate attorney has the swords and shields with which to defend it. Making sure you ask for testimony to be stricken, making sure you ask for bad questions to be stricken from the record, making sure you have your continuing objections noted for the record is a way to do that. When don't we do that? If it's a form objection, right? We don't need to be super lengthy if we're objecting to a leading question. We don't need to be super lengthy, if we're objecting to counsel testifying or if we're objecting to a lack of foundation issue. That we can keep short and tight and trust the judge to understand what's going on. But here's the big secret. Objections terrify everybody. The adrenaline in trial is an insane roller coaster ride, and then on top of it, you want me to throw in intense legal analysis about this issue while I'm telling this story and trying to convince 12 strangers of my point of view. The secret to all of it is to fake it until you make it. You just need to speak confidently. Rely on the format, rely on your position, rely on the case analysis and the work that you did to get to this point to ultimately bring you to success. Let's talk about tone of voice for a minute. When we are objecting, tone of voice can tell the judge everything about what the nature of the objection is. If I am typically an attorney who keeps a very reasonable tone of voice in my presentation, I don't vary too far in my register or in my volume presentation, and all of a sudden I am up off of my feet and my voice is ringing in the rafters, that communicates to the judge that something flagrantly wrong is occurring. It also communicates to the judge if we are apologetic for the fact that we have had to interrupt opposing counsel during their closing because they are stating facts that were never entered into evidence. So there is a difference between objection, I apologize, Your Honor, but facts not in evidence, may we approach, and having a fit for no reason at counsel table. Your voice is your instrument in the courtroom. Get to know it, play with it, use it, figure out who you are and how you can expand that, and apply it not just to your presentation to the finders of fact, but also to the members of the judiciary. It will serve you well. Situational awareness is the most important thing. You have to be able to read your room. You have to understand your judge. Where does situational awareness begin? By talking to the attorneys who come to the courtrooms that we go in before we ever go there. By sitting there and talking to the people who have been where we are going and asking, hey, when you object with this judge, what kind of preferences do you see? Does this judge have any objection pet peeves? For example, anybody who has ever been on the trial team or has dealt with trial team at USD will tell you that if you say at this time when you enter a piece of evidence around me, you can physically see my skin crawl. If I were a judge, that would be something that I would hope my attorneys would get to know and would cut from their language, right? Go and find the same things. Do your research. Just like we research jury pools, we need to research our judges because that way we can learn to recognize when our objections are causing more harm than good. When the judge is visibly irritated with you for your objections, you may be going a little bit overboard. Now, I will give a caveat to this in the situation of criminal defense. If you are protecting a constitutional right of your client, it does not matter how angry the judge gets. You get as indignant, as vicious, and as loud as you need to because it is that important. But outside of those situations, we need to learn to read the people that we are dealing with. We need to learn to read their body language, to know about their past decisions, to know what their preferences are in terms of how these things go so that we can use them to our advantage. Let's talk about offers of proof. When the judge rules against you, either on the admission of a piece of evidence or on a portion of testimony, you need to stop the proceedings and say, Your Honor, for purposes of the record, I need to make an offer of proof on this issue. Then we're going to tell the judge what would have come in under the rules had they not made their ruling. If testifying consistently with their deposition, this witness would state that the car at the intersection on the night in question was blue. This is permissible under Federal Rules of Evidence 401 and 403 as it goes to make a fact at issue in this case, namely who struck Ms. Watson more or less likely, and the prejudicial effect does not outweigh its probative value, Your Honor. But for Your Honor's ruling, I, as the plaintiff, would proceed in my case in a totally separate fashion. I need an objection noted for purposes of the record. It's dispassionate. It is not me telling the judge that I think they're wrong. It is simply a legal recitation of, hey, this is where I was going. This was what was going to allow me to go there. You didn't let me do it. I now have to change my case strategy. I need my objection for the record. This is to be used when it is a fact that you absolutely have to have or you do not have a case, all right? It is not something that you need to throw in the judge's face anytime they rule against you on any particular thing. But if it is something that would substantially change your closing argument or may even be so severe as to cause the case not to be triable in the first place, the offer of proof is the way that you save yourself and your case for the appellate attorneys down the road. Now we're going to go through some common objection examples. Once we conclude with this, we'll get into our question and answer period. Ambiguous. This is an objection that we want to use when we have an opposing counsel who is deliberately trying to trip up witnesses on cross-examination in particular, right? When the question isn't really a question, even if it is one of those short statements of fact that we use to cross-examine, there's not really a goal. So the witness is left floundering and is given the opportunity to hang themselves by their own rope, right? When that happens, the court has control under 611 to be able to exercise how we are asking questions. We need an actual question here, Judge. This is the objection that we're going to want to go to. Argumentative. When opposing counsel through their questioning tries to imply a causal relationship, and if X then Y, or because A then B relationship, we need to make the objection to argumentative. Argument is confined to closing argument when it is not considered to be evidence. We cannot allow them to slip this in during the course of trial. This is the appropriate objection. I'm not going to read each one of these to you guys because you've got the PDF, you've got the ability to refresh your own recollections as to them, but I want to talk you through each one of them because they are that important. This is a great way to make sure that you're calling opposing counsel out when they try to slide something past you or when they try to play a game. Don't be afraid to use it, and don't use it in a manner that is unnecessarily abrupt, right? When I say that, what I mean is anytime we are making an objection or arguing a legal issue, opposing counsel exists as a voice only. I train my students to not even look at opposing counsel during legal argument. Their focus is on the judge. That keeps you the most professional, that keeps you the most clean, that keeps it from becoming a bickering contest in the well, and instead is just about the judge deciding the legal issue. Asked and answered. This is one that is likely to get you an immediate ruling, right? But when we have a counsel who's continuing to tread the same ground over and over and over again and maybe changing a word or two in their question, we want to go to this. Be careful about using it on cross-examination, as the case law does say that we are entitled to develop cross-examination questions through repetitive asking to attempt to see if there is a change in the veracity of the story of the individual. But don't worry about overusing it when it comes to redirect examination. Redirect examination is not their chance to go back and ask all of the questions that would have been good for them on direct examination again. It is not an opportunity for them to retell their story so that everybody can see it. Instead, what it is an opportunity for is them to rehabilitate based on the questions of cross-examination. If they start going back and re-asking questions already covered on direct examination, objection, Your Honor, asked and answered, this was covered during direct. And now you've taken the wind out of their sails and they have to fumble for a better answer or sit down on a sustained objection. Assuming facts not in evidence. This is going to come up in the following situations. Either we're going to ask a question that contains evidence that hasn't been admitted yet, in which case we need to either lay the appropriate foundation and have that exhibit in first or not talk about it yet, or they argued a fact in the closing argument that never came into evidence. If the source of this objection violates a prior motion, you have to make a big deal about that. Pretrial conferences and pretrial motions practice are an exhausting thing because they take a lot of work to be able to fine-tune down what it is we're actually going to be talking about at trial. If counsel then violates all of that work, it is time for you to allow your indignation to show and say, this is unacceptable, Your Honor. We've already had multiple meetings about this. And if necessary, you demand the mistrial that you are entitled to if you are in criminal court and this has happened. These are the things that we are thinking about, and this format will help you use these objections to their highest level. Best evidence. Now, everybody knows that I absolutely hate the best evidence rule. It is my least favorite rule of evidence. And yes, I am that nerd that has favorite rules of evidence. 404B for the record. For the best evidence rule, however, if we're attempting to get to the contents of a writing and we haven't been able to show that it meets the requirements of the best evidence rule, then we need to go ahead and object. We need to show that it is either the original or a copy that was produced because it was not destroyed in bad faith under 1004. Very simple rule, something that usually gets involved when we're dealing with trusts and estates law in particular. This is something that's highly important and can trip up opposing counsel and yourself if you're not preparing your case the correct way. Bolstering. If they get up and try to make the witness sound like the best Pollyanna that has ever existed, that has never harmed a fly, and you have not done your cross-examination yet, you need to object to bolstering. They are not permitted to give credence to their witness's testimony until that credibility is attacked. And if they try to say something about how, well, in opening, they said there were going to be credibility problems, Judge, opening statements aren't evidence, as you're well aware. So there's no evidence at issue, so there has been no credibility attack at issue yet. Until you cross-examine, opposing counsel is not permitted to have their witness get up and talk about how they were an Eagle Scout and won the most honest award ever at their local elementary school. Compound question. This is a form question. This is not something where you should need to extend into the argument. This is something that happens naturally as we work as trial lawyers, but we need to call one another out on it because, again, The record is everything. So if you have somebody who's asking multiple questions at the same time, 611 allows the judge to tell them, hey, you need to break that up and ask one question at a time. Make use of it. Improper opinion. Anytime we are touching on something that requires someone to have specialized, heightened knowledge of a subject matter, of an area, of a particular set of rules or items, we are treading into expert witness testimony. And if they do not qualify, if they do not have the proper skills, knowledge, education, experience, or training in order to be qualified as an expert, then we must object to improper opinion. We must make sure that we are stating that there is not the appropriate knowledge here as required under the Daubert standards to get into this area of the opinion. Here's the deal though. As much as we refer to witnesses as lay witnesses and expert witnesses in common parlance, in the rules, there is no such thing as an expert witness. There's expert testimony. There's lay witness testimony. And just because someone is qualified as an expert does not mean that this objection is not available to you. Quite to the contrary, you need to make sure that that expert stays in their lane, that that expert is making sure they are only testifying to the things that they actually have the requisite skills, knowledge, education, experience, and training in order to speak on. A heart doctor does not get to talk about cancer. That's not how these rules work. Counsel testifying. This is a tricky one. Counsel testifying is when opposing counsel feels the need to insert commentary after the answers they receive to questions. It can be something as simple as yes or okay, but occasionally you get people who stretch the hubba bubba a little bit and do things like, I'm so very sorry to hear that about the horrible way in which your father passed away, ma'am. That's so awful. Okay, enough. Like, there's a difference between looping what the witness has said to you previously and going on and starting to talk. Remember, as the attorneys, we have an obligation to simply present the information. That's our job. We don't get to testify about it. Don't be the person who draws this objection. Objection cumulative. There is a very important thing we need to talk about when we talk about objecting cumulative, and that is this. It is not simply that the evidence is a reproduction or a duplication of something that we have already heard. Rather, the standard is that it be needlessly cumulative. It's needlessly cumulative. When is the line for when to do this? I tell students to use the Charlie Brown adult noise trigger in their brain, right? It's that moment in the lecture when you can't pay attention anymore and all you are hearing is wah, 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 wah. That is when we are at an appropriate moment for the cumulative objection to come into play. Because what we are doing now is we have covered so much ground and we have covered this in such depth that it is beginning to lose meaning. It's like when a word starts to sound funny when you say it too often, right? That's what we're looking for the objection cumulative. Objection lack of foundation. This comes out when we try to get into areas of testimony or into exhibits when we don't have the requisite proof that this particular witness observed it with one of their kindergarten senses, okay? By that I mean, did they see it? Did they hear it? Did they touch it? Did they taste it? Did they smell it? If they did not do one of those things themselves, they're not going to have the requisite personal knowledge in order to be able to testify, and you can't lay the foundation that you would need to in order to authenticate the testimony or any proffered evidentiary item, and you need to make this objection. Don't let people publish things in court before they've done the dance of admitting the evidence. We're going to talk about that in our next Law and Lunch. This is an important thing. Make sure that the foundations are clean. Make sure that the foundations are tight. Why? Not because we're being rude to opposing counsel, but again, that appellate record is everything. If it is not clear that this was justly admitted, you are risking losing all of the work that you did on this case to an appellate court. If we're objecting to hearsay, to opposing counsel's question, we need to be quick and spot on the money with when this objection happens. It needs to happen. This may be one of those situations where we need to interrupt, right? If we can tell that this question is going to call for hearsay and we know from our case analysis and preparation that that particular answer is going to be real bad for us and has huge problems and it's hugely prejudicial besides, we're up out of our chair and we're not only objecting to the hearsay, but the consummate advocate adds in the relevance objection afterwards. Your Honor, this is impermissible hearsay for which no applicable exception or exclusion could possibly apply, and if the jury were to hear it, its prejudicial effect would far outweigh any probative value that it has. It must not be permitted to be heard here in testimony today. We'd ask the question be stricken from the record. That level of confidence when speaking about objections comes from familiarity and playing with the language and playing with the rules and having the confidence to call people out and make them do it the right way. If we're going for the witness's answer, when I am dealing with it, I'm going to go ahead and do the same set of language. But I want you to pay attention to the note that I have here on criminal cases in particular. If we are dealing with testimonial hearsay, i.e., statements gathered for the purposes of a criminal investigation, and you as the defense attorney know that you have not had the opportunity to cross-examine that witness, you have to get out your copy of the Constitution that we all as lawyers keep in our pockets and wave it very, very, very much in the judge's face and say, not no, but heck no, are you doing this to me, to my client, and to the Constitution? We are not going to allow the confrontation clause to be violated through hearsay. Speaking of which, take your time and do your research in this particular area right now as we come back to trials in person again. Make sure they are bringing the people that they have to bring to prove the case against your client. Improper character evidence. Opposing counsel just elicited whatever the thing it is that they did wrong, whatever character trait, whatever adjective, whatever personality description they had given that violates the federal rules of evidence under 404, either for propensity arguments or character generally in civil cases, or if we are in a situation in which they are trying to offer specific instances of conduct as proof of character rather than reputation or opinion evidence. Those are both things that we can object to. Character evidence can best be simplified like this, you guys. If it would be used as a way to describe a character in a book, then it's character evidence and we don't need to talk about it. If it could be used to describe a character in a book, if it's an adjective, if it's joyfully, meanly, angrily, violently, those are the words that we want to be looking for in order to get to this objection. Improper characterization, however, is when opposing counsel's question takes things and spins it in a way that's impermissible. And we're not going to allow that to happen. We're not going to allow there to be some kind of suggestion of what it is that they're doing, and you ground that in 404 and 405. Improper impeachment. Let's review impeachment. If I am impeaching with a prior inconsistent statement, I need to remember my 3 C's: commit, credit, and confront. Commit, I get them to commit to the in-court testimony that they have given. I'm then going to credit the past testimony that I have with them by asking a series of questions that goes something like, this isn't the first time you've spoken about this. You gave a deposition in this case. You were there. I was there. Opposing counsel was there. Court reporter was also there. She took down every word you said. You had the opportunity to review the transcript, to change anything, to make any additions. You didn't change anything. You signed it at the bottom. And when the court reporter started typing, she made you take an oath, like the oath you took here today. Then I'm going to move to the confrontation stage of impeachment, and I am going to say, calling court and counsel's attention to page 15, lines 16 through 24 of the witness's deposition, where witness you said. And then I'm going to read out loud the prior inconsistent statement. And here's the deal. If it is a deposition and it falls under the categories described under 801 D1A, I'm then going to mark that section of the deposition as an exhibit and admit it because I can use the hearsay rules to do that. But if somebody doesn't go through those steps and just tries to shove a deposition in somebody's face, objection, Your Honor, the standards for impeachment are laid out in 607 through actually 613. We'd move to strike. You can't let somebody impeach improperly. Now, 401 as a relevance objection is not something that most of us are ever going to make. Why? Because the bar for 401 is so excruciatingly low. That doesn't mean that we don't need to make sure that we are familiar with how those objections go, however. In fact, quite to the contrary, what it helps with is the ability to pause and give ourselves an easy one, right? This is kind of the softball when we're practicing our objections. So in order for evidence to be relevant at trial, it needs to make a fact at issue more or less likely than it would otherwise be. If I can't show how that needle is moving, then we cannot have this fact be admitted into evidence. When do we do this? Solo? Hardly ever. Most of the time, we're going to combine it with this objection, the objection to relevance under 403. And Your Honor, even if you were to find any slight indicia of relevance under Federal Rule of Evidence 401, surely under 403, it's going to be committed. it's going to be excluded. And the reason that it would be excluded is because the probative value of this proffered evidence is substantially outweighed by the danger of unfair prejudice because of the issues that this document contains. Pause. You go through and you combine. When you combine both of them, when you use 401 to say there's not really anything about this that's relevant, but even if it is, you then get to make the bar of 403 seem so much higher than it necessarily has to be. And you get to use that to your advantage in the argument. You get to say, here's the exact way that this is unfairly prejudicial. Here is the exact way that this will cause confusion of the issues. Here is the exact way that this is going to waste judicial economy and be needlessly cumulative. It gives you the format. It lets you move through it. This is going to be most commonly used when we're dealing with exhibits and in pretrial. Relevance objections are extremely difficult to win at trial, but that doesn't mean that we don't make them because, again, the appellate record is everything. Again, this is just going to be the commentary. This is the combination of the two of them as we discussed. Let's talk about leading. It's a very simple objection, right? This slide's almost a little bit humorous, but it's an important objection that you need to be ready to make. Please don't make it on cross-examination. But if you are dealing with somebody who on direct examination keeps using leading questions, you have the right and the obligation to object to that and make them open the question setup. They don't get to just handhold the witness through the testimony because they're having a difficult day. Make them go back and ask who, what, where, when, why, describe, please explain type questions, or move on in the area of testimony that they're covering. Misquoting the witness and misstating evidence. Don't expect to win this objection, hardly ever. But when you need to interrupt the flow and you know that this is happening, this is the way that you do it. And you point to the fact that the court gets to control what's happening here. And you point to the fact that opposing counsel can rephrase in order to fix it if the judge doesn't sua sponte do it on their own. If the judge is with you on this, they're going to sustain it and make them rephrase. But it's still something that you need to keep in your pocket for when that situation is happening. We all know that objections to a certain extent end up being a strategy piece of trial because we've got to make sure we're protecting our witness and our client's rights and the position that we are taking here in court. But we also have to make sure that we are using them judiciously and within the bounds of the rules and the bounds of ethics. If we have somebody who is misquoting and misstating things over and over again, you have an obligation and duty to point it out. Narrative. That's it. It's like the leading objection. It's not complicated. When do you suss out when the line is? My rule of thumb is 3 sentences is just enough. If we are getting beyond 3 sentences in an answer, we are getting into a narration, and opposing counsel can break that up appropriately. Speculation. Let's talk about speculation for a hot minute. Speculation is when we ask a witness to peer into the mind of another and tell us what they were thinking, what they were feeling, what they were doing, and why, to peer into the mind of what's going on. We don't let that happen at all in court. We don't let lay witnesses do it. In fact, in criminal court, we don't allow psychological experts to opine upon the mental state of the criminal defendant at the time the offense was committed because of how serious this is. We cannot allow somebody to start to speculate on what's going on simply because they think they have some idea. If they're trying to be that much of a mind reader, you need to get indignant and you need to point out the lack of personal knowledge that this witness has under Federal Rules of Evidence 602. And since they did not sense this with one of their kindergarten senses, we cannot be talking about it, right? It's the whole point. Unresponsive. This is when you have a witness who on cross-examination, no matter what control technique you employ, no matter how you ask, no matter how polite you are, no matter how much you try to insist that you are just trying to do what you need to do to get the answers out of them, they refuse to answer your question. When that happens, and it will, you can turn to the judge. You have to show the judge that you've attempted control techniques first. Control techniques like, ma'am, I apologize, maybe I wasn't clear. That wasn't my question to you. My question was far simpler than that. My question to you was, and repeating your questions. Control technique like repeating the question a couple of times. Control technique like, ma'am, you understand that you're in court. You were prepared by your attorneys. They asked you questions. You answered. I'm asking you questions. You refuse to answer. These are things that you try before we go to this objection. It is never on the first attempt or when the witness first gets cranky that we go running to the judge. Instead, we try something else before we use this, but it is available to you to be used. That is going to conclude the screen shared portion of the day. And so now we're at the question and answer period. And what I like to do with CLEs like this is, what are you experiencing? What's frustrating you? What's causing you heartburn when you're dealing with objections in your practice now? And let's figure out a solution together. This is the time when the attendees interact with the instructor, thus enhancing the learning process. Y'all, go ahead and put your questions in and we'll get started. Okay, Casey, thank you for that. Can you discuss impeachment objections based upon use of extrinsic evidence? So let's talk about this for a hot minute. What Casey's talking about here, Casey, I think if I'm hearing you correctly, is an impeachment for credibility under 608, where you have the knowledge and you're basing this on credibility alone, and you can't use the extrinsic evidence to come in and back it up. You can't use that prior inconsistent statement because we're not impeaching on an inconsistency, only upon the truth of the statement, the veracity of it or not. When you want to make that objection, if the impeachment is going improperly and they are impermissibly using the evidence, you point back to 608 in the way the impeachment language is specifically worded, which is to say that no extrinsic evidence is permitted under 608. 609 is a carve out from 608. 609 deals with our criminal convictions, right? When I'm dealing with criminal convictions, I can have the extrinsic evidence of the conviction, but I can't do that if I'm just dealing with an issue of credibility under 608. So if you see that, what you do is you call it out as an improper impeachment objection. Your Honor, under federal rules of evidence or the South Dakota equivalent 608, we do not permit extrinsic evidence to be used for this type of impeachment. This is an improper impeachment, must be stricken from the record as both the questions and any portions of testimony that are going to deal with it. That's going to be where you're going to ground yourself for that. When do I recommend speaking from chair or asking for sidebar? If it's a form objection, speak from your chair, right? If it's something that you think is going to be resolved relatively quickly or based on your knowledge of your judge, you think they'll go through and be done fast, then go ahead and make your objection from your chair. But if it's something that's going to require intense legal analysis, if it's any kind of hearsay discussion whatsoever, then I think you ask for the sidebar. Why? Because jury members are curious. They want to know what's going on. They instinctively lean forward when we start getting into the objections with the judges, right? Because they want to know what's going on and what we're doing. You have to stop, you have to break it down, and you have to say, okay, this is going to be more intense, and if I don't get a sidebar where I can talk to the judge without the jury being able to lean in and listen to me, they're going to get distracted here. Use that when you want to switch the narrative. It can also be a momentum shift in the trial, right? If you think about it from a strategy perspective, if you know you've got a lengthy objection coming up and the momentum has been going their way, that's a perfect time to ask for a sidebar where the jury is sequestered so that you can have that lengthy conversation. I hope that helps, Carrie. What other questions do you guys have? Oh, the form and function objection. Ask for specificity. Be polite about it. But if it keeps happening, Your Honor, I apologize. I'm not quite sure what opposing counsel is referencing. If he could give me a little bit more grounded in the rules objection, I'd be happy to respond to his concerns, right? That's a way to call that out. Form and function of the question, that leaks over from depositions into trial work, right? Stop, pause, and make them be more specific. You have the right to ask for that. And if it gets a little ridiculous, maybe talk to them outside in the hallway and say, hey, what is it that I'm doing that's crossing sideways? Because I'm not quite sure what's going on here. Remember, just because the system is adversarial doesn't mean that we have to be that way with one another. Slow yourself down and see if that helps out. Okay, how do you deal with a judge ruling on a hearsay objection and sustaining it before the witness has answered? Specifically when the question did not call for hearsay, but the witness says the word "she told me" and opposing counsel immediately objects. Here's what you have to do with that. That's that offer of proof language that we were talking about before, right? If they sustain the hearsay objection and you have a firm if you have a good faith basis to believe you have an exception or an exclusion that would apply in that situation, Your Honor, I need to make an offer of proof on this. If testifying consistently with her past testimony, the witness would have testified to X, Y, and Z. These are permissible under the rules of hearsay because it is an exception based upon, let's go with 8033, the then existing mental or emotional state of the declarant, right? It applies under this rule. This is how it applies. Therefore, it should have been admitted. But for Your Honor's ruling, I would have proceeded in my case in a different fashion. I need my objection noted for the record. That offer of proof language is the magic language to get the judge to back up and realize they've caused a problem that they now need to go and fix. I hope that helps. When it comes to objections too, the other good thing that's really good practice, you guys, is to just go and get a copy of the rules of evidence and refresh your recollection as to how they work and how they're currently worded. Remember, they get updated, right? We've had a couple of updates the past few years to allow for automatic authentication of blockchain technology because of the amount of Bitcoin trading that we're seeing going on. We're also seeing other changes to the authentication technologies. And just this past year, 404B got an update in order to remove it only from criminal consideration, but also be added into civil when appropriate. That's huge. Things are constantly changing. Make sure you're keeping yourself up to date. I'm glad it helped, Casey. I'm glad it helped, though. If there's anything else that I can help with, my email address is laura.rose@usd.edu. It's on the website. You can find me. I'm usually pretty good about responding to emails relatively quickly. I try to be. If you've got a specific question, I'm here for you guys. I'm more than happy to help out in any way that I can. And if there are any other questions, I'm happy to answer them.
Professor, it looks like there is a question in the chat, if you wouldn't mind taking a look there.
There we go. Okay. Examples of bolstering. An example of bolstering would be something like opposing counsel has the witness on the stand. Ma'am, tell us what it is that you do with your spare time over at the soup kitchen on 40th Street. Okay, now the little old lady is the soup kitchen lady over on 40th Street, and she hasn't said that yet. She can testify that she does that, and she can open that door, but the attorney can't choose how they're going to frame the witness outside of the testimony to try to make them sound more credible, to give them that Boy Scout, to give them that moment of, oh, look, they're so good, they're so nice, they're so kind. If they do that, they are impermissibly lending their official weight as an officer of the court to the witness's testimony. Anytime you feel that, right? We can all feel when an attorney is doing that. We can all feel that moment when somebody is lending their support to somebody else. We can't do that in court. It's not permissible. So if it's not going to be permissible, don't let them do it and call them out for the bolstering there. I hope that makes sense. Another example of it would be if you've got a prosecutor, right, who's got an investigator on, and in your 15 years of decorated experience, when the witness hasn't testified to that yet. Objection, Your Honor, bolstering. It's bad enough that he's in here in his uniform testifying. I shouldn't have to deal with the prosecutor talking about how wonderful he is too. And I can say that because I was a prosecutor. That's the only reason that I get to make that joke. It doesn't look like there are any other questions, and I know that we're a little bit early, but what I will tell you all is, once again, I am available as a resource to each and every one of you if you ever need it. Please feel free to email me. I will get back with you as quickly as possible. We have a very cool and very busy season coming up for the trial team here at USD, and I will let you all know as the first group who gets to actually hear this information. We have been contacted and we will be featured on a podcast documentary about trial teams. USD is being one of the featured schools of about, I think there's a field of 10 of us that they're focusing on, but we are going to be part of this. So keep your ears peeled, I suppose, for that one, and we will send you updates. But as always, if there's ever anything that I can do that's helpful, if there's ever anything that you're struggling with, if there's something that you think that you just need somebody else's brain to bounce it off of, I'm here and I'm happy to help. Thank you guys so much for having me here today, and I can't wait for our next one here in a couple of weeks.
Okay, I hope people can hear me. I've been having some technological issues. So first, I would like to thank Professor Rose. This was, it was fabulous. It was a lot of information that I was taking over lunch. If those in attendance have any additional questions, you can also contact the State Bar at info@sdbar.net. And they can be forwarded to Professor Rose, but she did give her email, so feel free to do that too. Once you leave the webinar, you will receive a survey on the presentation. We would appreciate it if you would complete that and provide your feedback. And on behalf of the State Bar of South Dakota, I thank you for joining us, and I hope everybody has a great rest of the day.